Yes, we are aware of the decision of the Attorney General of Osun State to withdraw the suit filed against the Attorney General of the Federation and a fortiori against the federal government with respect to local government allocation that Osun State government was complaining has not been released to their preferred administrators of the local government councils in Osun, the fake sit-at-home councillors and the chairmen that they purportedly elected without a general election in Osun State on the 22nd day of February 2025. However, that particular suit filed at the Supreme Court, which was withdrawn today, I'm sure was withdrawn due to two basic reasons. One is the fact that that suit itself is incompetent because the Attorney General of Osun State filing an action against the Attorney General of the Federation, that is not a suit. The subject matter of that suit is not one that the Supreme Court will want to exercise original jurisdiction on. That is a suit that is better brought by the local government councils in Osun themselves, complaining of failure of the federal government to release to them the allocations they probably might want to believe was due to them. But for the Attorney General of Osun to bring such an action and be complaining that funds due to local government, which is the third tier of government in Nigeria, that funds, we are no longer in 2003 or 2007 when the state government enjoyed the freedom to convert local government funds or even subjugate local government administration to its appendage. We are now in an era with the decision of the Supreme Court in AG Federation and AG Abia State and 35 states of the Federation. We are now in an era courtesy of the current Attorney General of the Federation, Prince Lateef Fagbemi SAN, and the President of the Federal Republic of Nigeria, Asiwaju Bola Ahmed Tinubu, GCFR, who approached the Supreme Court to determine whether state governments could still continue to subjugate local government administration to a state of appendages anymore. And with the decision of the Supreme Court in that case, saying that local governments are the third tier of government in Nigeria, who are entitled to their allocations directly from the government of the Federation, and the state government will no longer act as conduit pipe through whom such money will get to the local government councils anymore. That has terminated the middleman role that state governments were playing before. So the case brought by the Attorney General of the State of Osun against the Attorney General of the Federation at the Supreme Court was doomed to fail. And more so, with the defense filed by the Attorney General of the Federation under the representation by Chief Akinlolu Olujimi SAN, whereby if that case were to even proceed, the government of Senator Ademola Adeleke would have been liable to refund hundreds of billions of naira that it had wrongly collected over the years, that it had misappropriated monies that belonged to the local government. So that is one reason why they quickly rushed to go and withdraw that suit, because Osun will be damnified in heavy costs and damages that it will definitely regret that it ever approached the Supreme Court for such a frivolous and reckless action. On the other hand, is the fact that the desperation that informed filing of that suit at the Supreme Court was betrayed by the fact that they had filed a similar suit at the Federal High Court in Osogbo few days or weeks before they filed this wrong suit at the Supreme Court. What they were praying for at the Supreme Court is the same thing that they are still praying for at the Federal High Court in Osogbo, where they sued the Attorney General of the Federation together with the Central Bank of Nigeria and the Accountant General of the Federation. So that suit is still pending, praying for the same thing that they were praying for at the Supreme Court. The implication is that the suit filed at the Supreme Court, which they now withdrew today, has always been an abuse of court process all this while. They just realized that. And on what basis would the Attorney General of the Federation even be fighting the cause of the local governments if the local governments believe that they are in any way affected by the powers or acts of the federal government? They are juristic personalities in law that can approach the courts. So for the misadventure that the Attorney General of the state of Osun is engaging in, even right now at the Federal High Court, is unfortunate that such step is being taken in this era when we have gone beyond the time when local government administration was regarded as an appendage of state government. I will not be surprised if within this week that suit pending at the Federal High Court is also withdrawn. Right now, the state of Osun, the Attorney General of the state of Osun, masquerading through PDP, NOLGE, and so many other organizations, I have nothing less than about 10 cases in court on this local government fund alone. And you can imagine, that shows how desperate they are, because it means that with the federal government saying that the Supreme Court judgment in AG Federation and AG Abia and 35 others delivered on 11th of July 2024 should be enforced by all persons and institutions in Nigeria. With that line of action being on ground, the government in Osun has not been able to get money to divert or misappropriate again, with the government putting the judgment of the Supreme Court into enforcement, because with that the money must come to the legitimate, duly elected administrators that were reinstated by the Court of Appeal judgment of the 22nd day of the 10th day of February 2025. Those were the people who were elected on October 15, 2022, and were wrongly sacked by the Federal High Court and removed by Governor Adeleke